In our Jan term class, Check All That Apply, we've been thinking deeply about what it means to be multiracial and multi-ethnic in the United States, both on an individual and institutional level. In the next few minutes, I will share with you some quick facts about multiracial America. Two very important things to consider. First, interracial relationships have a long-standing history in the United States. Interracial relationships and multiracial individuals have been part of our society for centuries. Second, the United States has a long history of statutes that we call anti-miscegenation laws, which specifically legislated against interracial marriage, particularly when one party was white. Two questions to think about that we'll do later in our breakout sessions. First, if the United States has such a long history of interracial relationships, why is multiracial identity considered such a new social phenomenon? And second, why do you think that the vast majority of anti-miscegenation laws had to do with whites? What does this tell us about race relations and racial privilege in the United States? Mildred Jeter and Richard Loving were married in 1958 in Washington, D.C. They moved back to Virginia shortly thereafter and were arrested while sleeping in their bedroom for being in violation of Virginia's, quote, Racial Integrity Act. Mildred was pregnant at the time. They were both charged and sentenced to prison, which the judge suspended if they promised to leave Virginia and not return for 25 years. They moved back to Washington, D.C., but frustrated with not being able to travel together to visit their family, as well as the financial burden of living away from their families in Virginia, they protested to the Attorney General in 1963, who forwarded their case to the ACLU. A 4-year legal battle ensued, ending with the Supreme Court finding that Virginia's Racial Integrity Act was unconstitutional. In 1967, there were still 17 states with active anti-miscegenation laws. The Supreme Court's decision in Loving v. Virginia struck down these remaining statutes. The map shows the year which each state repealed their anti-miscegenation laws. The gray indicates states that never had anti-miscegenation laws. The green indicates states that repealed the laws prior to 1887, and the yellow were states that repealed their anti-miscegenation laws between 1948 and 1967. The states in red were the final 17 states that were overturned with the Loving v. Virginia decision. (2000) was the first year that the U.S. Census allowed respondents to, quote, check all that apply. Think about this in terms of what we've already learned. The U.S. has a long-standing history of multiracial and multi-ethnic individuals, yet it wasn't until 2000 that Americans were able to demonstrate that in our census. What does this mean, and why is this significant? Again, these are questions that we've been talking about throughout the last couple weeks. In the first Check All That Apply census in 2000, about 2.4 of the population, or just about 6.8 million people, selected more than one category. The state with the highest number of multiracial respondents was Hawaii at 24.1%, followed by a distant second of Alaska at 5.4%. Less than 1% of the respondents from Mississippi, West Virginia, Alabama, Maine, and South Carolina identified with more than one racial category. Data from the 2010 census estimates 9 million multiracial and multi-ethnic Americans. This is a picture of my parents, of my family, my parents, my husband, and our children, Dylan and Cameron. Thank you all for watching this podcast, and I look forward to our class discussions and reflections.